half black, for example, that elects only one congressional member and everybody else goes to the Republicans, that would represent that population in some ways. So if that is gutted, Democrats could lose 19 seats.
Damn,
this would
son.
be a huge amount.
It's like, why are you drawing your district for the blacks versus for the Hispanics? You're going to carve that up for one group as opposed to another group, and one group gets preference over another? That's strange. Feels kind of racist. He was just explaining, without saying it, that, yeah, I mean, they could end up on a list and somebody could look at a list and then maybe send that to the county attorney who could go investigate and prosecute them. Okay. So did their votes count or not? Democrats are free. The Supreme Court is about to hear a case coming up in their docket called State of Louisiana versus Philip Cayce that talks about voting rights, and in particular, the Voting Rights Act. And we're going to go through this, but after we see the implications of what this could mean if the Supreme Court comes back out and says, you know what, racial gerrymandering, using race to create districts, is actually unconstitutional. It's inappropriate for governments to be doing that, to create little special districts to try to balance the scales on these things. And if the Voting Rights Act is found to be unconstitutional, Democrats could lose 19 of their rigged seats in Congress. While California is trying to cram through SB 50, and a lot of the blue states have already been playing this game for a long time, trying to rig the census so they get more apportionment by undercounting the red states and overcounting the blue states, by bringing illegal aliens into their sanctuary cities to get more congressional budget and appropriations and more congressional representations, which leads to more electoral votes. If this comes to a stop, they're in big trouble. And so before we get into the final reply before oral arguments in the Supreme Court that is queued up now, here's some background on what is going on and why they're so nervous about this from CNN out of their own mouths.
Actually represents pretty accurately, mathematically, how the country is divided over the question of the presidency. But if you look at this is what the party pickups would be for congressional districts. Republicans, 5. Missouri, 1. North Carolina, 1. Ohio, 2 or 3. Indiana, 1 or 2. Florida, still discussion down there, but that could be another gold mine for them if they tipped it even further their way. Kansas, 1. New Hampshire, 1. And Nebraska. Democrats, Utah, California, Maryland. Look at this. If you offset California and Texas, Missouri and Utah, North Carolina and Maryland, everything left over is an advantage to the Republicans.
Nice.
And don't forget, the Supreme Court is considering what could really be the end of the Voting Rights Act, which would protect minority groups. So you don't have a state that's half black, for example, that elects only one congressional member and everybody else,
protect is what they say. In other words, rig it,
goes to the Republicans, that would represent that population in some ways. So if that is gutted, Democrats could lose 19 seats.
Damn,
this would
son.
be a huge amount. But this is also a measure of how much the White House is concerned about this, because Donald Trump knows if the Democrats get the House again, there could be new investigations just like last time. There could be a new impeachment. There could be a lot of impediment to these plans that right now the Republicans in the House and Senate are letting run like a freight train.
Let's go. All right, so we don't want unconstitutional voting rights laws that try to rig House seats for certain groups of people in America. And now the Supreme Court is going to be hearing the case. And so a little bit more background. From CNN, their perspective on this is that the Supreme Court is poised to gut the Voting Rights Act, and there's already been some slow kind of whittling away at it. 2 years ago, for some backdrop, the U.S. Supreme Court surprised observers and even some inside the court when it narrowly preserved the Voting Rights Act, 1965, and what it created, which were race-based remedies that were intended to counteract historic discrimination against blacks and other minorities. But new signals from the current justices point to a reversal and suggest a looming retrenchment of the landmark civil rights case. The court be on the brink of forbidding the consideration of race in redistricting and eroding the state's ability to consolidate blacks or other racial minorities into majority-minority districts to boost their chance of electing a candidate of their choice. And you've seen that in the maps of all the states. You see all the districts. And you have the ones that are like, big chunk over here, little squiggles over here, little, connects it over this way. You have a big chunk over here and connect it over here, or it's like all, kind of jagged and just cobbled together. That's because they're going through like, oh, okay, all the black people over here, loop around. Okay, all these white people, no, avoid that. Get over here, a little bit more black people over here. Get rid of the whites or blacks over here. And they create the districts. And that's dividing people by race, which I thought was inappropriate to do that. But now we're going to go back and revisit it. The long-standing Voting Rights Act was a cure for discriminatory maps. It's now going to be argued this week at the Supreme Court. The controversy originally held last March, but the justices could not resolve it at the time. And so they've ordered new arguments. But when they do, they've been known to rule far more consequentially. Okay, they're like, we got to hear this again. And now we're here. In the redistricting fight, the court announced in August that it would expand the legal question to squarely answer the following: whether voting rights acts and remedies creating districts that are tied to race and used for decades, why they might violate the Constitution's guarantee of equal protection under the law, under the 14th Amendment. The eventual decision would affect the fate of candidates in the 2026 midterms and reverberate all across the country for years to come. That's why it's so important. Here is what the final word was from the state of Louisiana. Writing from the DOJ down at the state level, Elizabeth Murrell, Attorney General, sends this one in to the Supreme Court saying, all right, look, if you have race-based redistricting, that is inappropriate for these reasons. They say, all right, Supreme Court, here's the final word on this. The court should decide this case on constitutional principle and not statutory plastic surgery, cobbling it all together. In the redistricting context, the whole point of the enterprise under Section 2 of the Voting Rights Act is to draw additional majority-minority districts with an express racial target in mind. Okay, they're saying this is what the law says, both to prove up a Section 2 plaintiff's case and to install a remedy for any violation. A lot of technical stuff here. She says, but to hear them explain this to you, court, this is a good life. Like they're trying to cobble together a bunch of stuff, and they say this is great. They praise this as brilliant, and they love the clarity and the exactness. They refer to this case, and they say, oh, no, it's not too racist or anything. There's safeguards, there's guardrails, and we're allowed to do this. But this is not real life, okay? As we've seen in other cases. The reality is that the Voting Rights Act and the Section 2 and the race-based redistricting mandate as implemented by the court in case law is both unworkable and it's unconstitutional. You can't just cobble this thing together. That is why parties and amici, have friends of the court, have flooded the docket, as we just showed you, with myriad proposals for repairs. Well, let's just fix the Gingles case. We'll just fix Gingles. We'll just give it some updates and renovations, and we'll just, modify things a little bit. They say it's ridiculous. That's going to make Frankenstein blush. It's like hacking together all the body parts. But no amount of surgery can eliminate the constitutional defects inherent in a system that, at the end of the day, requires states to sort their citizens by race and to create these little districts of similarly colored people. To that end, 3 points warrant emphasis as briefing closes in this case. 1, you, Supreme Court, should affirm the judgment below on the independent ground that the government may never use race as a stereotype or a negative. We don't carve people up by race in America officially. And second, the court should affirm the judgment below on the independent ground that race-based redistricting lacks a logical endpoint. And third, if the court thinks it's necessary to step into strict scrutiny frameworks, race-based redistricting is not a compelling interest, okay? And so strict scrutiny is one of these standards of review. When we say, what does the law say? And we apply the law to the Constitution, and we ask, is this law constitutional or not? There's different methods of analysis. Rational basis review, you measure the law against the Constitution using a test that's basically rational basis review. Very low level test. Strict scrutiny is the highest level because it's infringing on a constitutional protection. So if they're going to infringe on that, they got to have a very compelling reason to do that. And the courts have called that the strict scrutiny standard or the strict scrutiny test. So is there a compelling interest for carving up the states based on color? No, they say, if you even have to get there. Now, this case should begin and end with the twin commands of the Equal Protection Clause that the government may never use race as a stereotype or negative. And they say it's unconstitutional principally because it rests on a racial stereotype. It says all voters of a particular race must, by virtue of their membership in their racial community and class, think alike, share the same interests, and prefer the same political candidates. And that's what the Democratic Party relies on. That's why they carve everybody up and treat everybody like trading cards. We got 2 trans, 1 gay, and 3 blacks. I got a full house or whatever. As Louisiana explained, that class-based stereotype is baked into the case law, and it's unconstitutional. It focuses on the minority group in each of the 3 preconditions. Now, that racial stereotype is at odds with this court's precedent. At the heart of the Constitution is a guarantee of equal protection. The court has said, and it has said lies the simple command that the government must treat individuals as citizens as individuals, not just components of some sort of racial class. Gingles violates that command. It's illegal. And so too does each federal court and state that tries to draw district lines with, quote, an express racial target in mind, which they do. California is doing it right now. Some top-aside amicus briefs try to downplay this problem. They say, well, the case law avoids stereotyping by requiring a plaintiff to show that the minority group group is politically cohesive. And by that logic, they say, that requires a consistently strong shared communal presence. And again, it's basically racist. So that argument implies that the political cohesion requirement compels Section 2 to show that every single minority voter shares the same political preferences. It's not accurate, not even close. It's racist to presume everybody acts the same. According to another topside amicus brief, they're referencing a bunch of the other filings, the most common presumption applied by lower courts is that political cohesion exists if more than 60% of the relevant voters typically support the same candidates. Well, if that number is correct, you know what that means? If it's 60%, it means the other 40% are not the same. But the Gingell's framework carries on with its focus of minority groups and the minority preferred candidate. And it is racial stereotyping. The 14th Amendment forbids it from happening. That's why we had the Civil War and all of the Reconstruction amendments. Also inherent in this race-based redistricting is the improper use of race as a negative. In zero-sum contexts like this, a benefit provided to some but not to others necessarily advantages the former group and hurts the other. Creating a safe district for a minority group with allegedly shared political preferences comes at the expense of voters of other races who may have different political preferences. It's like, why are you drawing your district for the blacks versus for the Hispanics? You're going to carve that up for one group as opposed to another group, and one group gets preference over another? That's strange. Feels kind of racist. To its credit, one topside amicus brief owns up to this elementary arithmetic. If you add one to one side, you have to subtract it from the other. And the same elementary arithmetic shows the effect on non-minority voters as well, saying that a surplus of non-minorities cannot be negated without an offsetting reduction. And so it's one at the expense of another. Of course, we know who is at the expense of. Independent of those defects, race-based redistricting is also unconstitutional because it lacks a logical endpoint. Just goes on forever. Neither the appellants nor the amici have a serious answer to this problem. One brief tries to avoid this problem by insisting that there is no racial classification in play. They say, well, the law doesn't classify on the basis of race. The law doesn't say that. And it also claims the requirement of a time limit doesn't apply to it. But they say that's frivolous. The question in this re-argument that we've already heard arguments on is this: whether intentionally drawing a majority-minority district, as the court has interpreted Section 2, is constitutional. By definition, it is impossible to draw a district without racially classifying citizens. Hence the problem that the authority to conduct race-based redistricting cannot extend indefinitely into the future. And so the appellants and the amici, they struggle to identify any conceivable logical endpoint. Like, when does this end? Like, when is it good enough that we've all commingled or whatever? And when can this finally stop? They don't even want to talk about that. And Section 2 has not resulted in what they've said it's going to promise. So it's not serving the ends. It's not compelling as a solution. The Robinson appellants also devote a lot of their attention saying, well, Section 2 will self-sunset once current conditions, whatever they say they are satisfied. Now, they say it's astounding to see that these appellants represent, they say nothing in Section 2 ties violations to data or practices from the distant past, like literacy tests or low voter registration and turnouts in the 60s and 70s. While they say that Section 2 will phase itself out once the people who are filing the lawsuits can no longer satisfy the framework, it's misleading. The argument doesn't address the South. The Robinson appellates and their self-sunset theory, like, it'll just naturally expire once we don't need it anymore. Now, in a vacuum, this theory suggests that it's going to take care of itself throughout the entire country. But that is where everyone gives the game away. Where do residential segregation and racially polarized voting remain high? Where? Only in the Black Belt of the Deep South, comprising portions of Alabama, Arkansas, Georgia, Louisiana, Mississippi, South Carolina. So the proponents of Section 2, of drawing these districts up, freely admit that it has real teeth, just in places like the Deep South, where minority voters are still residentially concentrated and voting is still highly racially polarized. And no one knows if ever that's going to ever change. If it never does, then Section 2 will never sunset. So in that way, this self-sunset theory is also a de facto version of the equal sovereignty problem that this court has also criticized before. True, the equal sovereignty issue, there was written into the Voting Rights Act, they put it in there. But the state's entitlement to equal power, dignity, and authority is still valid. And in all events, the self-sunset theory is not going to solve itself, right? If it is continuing to be a problem, it will continue to exist. And so this is not a compelling interest. There's no reason for us to have this. Remember, compelling interest, if the government is infringing on your right, in this case, it would be the right to be treated with equal protection under the law, under the 14th Amendment. Everybody gets treated the same. You don't carve up one group against another group. Like, we're going to create a black district over here so that the white people don't have it, but all the Mexicans and Hispanics are sitting around going, "Que pasa? The heck's going on over here?" From these other independent grounds for reversal in that case. I mean, they're being, so how about we just don't play one group against each other? Now, that is deeply important in Louisiana's view. They're not satisfying strict scrutiny. There's no real compelling reason that this is achieving. Now, that is deeply important in Louisiana's view because affirming on those grounds would shut down arguments in future cases that race did not predominate in a particular map. They say strict scrutiny is inapplicable, right? If you're carving people up by race, if you're treating people as a group of people based on their race and the laws are impacting you, we say you're a suspect class, okay? We don't want that to be happening. So we're going to add some pretty compelling, like if a law is going to say only black people can drink at this water fountain, you're like, you're carving up a group of people based on race. That's inappropriate to do. So we're going to say you're a suspect class. And if there are laws that are directed towards that suspect class, we have to be very careful with those and we apply strict scrutiny. Now, and to be clear, there is a very serious risk that they're just going to say, well, no, race had nothing to do with this map. It just happened to carve out all of these groups and just say, so we don't need to apply strict scrutiny because the carve out is not about a suspect class, right? So we don't need to apply that high standard. It's just a lower standard called rational basis review, which just basically means if there's any rational basis for the law, then it's good enough for them. But this is a risk. They're just going to try to classify things that are race-based as not race-based. But if the court doesn't like our first two arguments and you do proceed to strict scrutiny, there are a number of reasons why race-based redistricting is not a compelling interest. Rather than recount them all, the state here focuses on one in particular, where Robinson, the appellants, and their amici severely misapprehend the court cases and the state of the law. In prior cases, the court observed that its precedents have identified only two compelling interests, okay, so it's got to be a really good reason that permit resort to race-based government action. Okay, it's like can't just, pass laws that target races. One is remediating specific identified instances of past discrimination that violated the Constitution or a statute, while the second is avoiding imminent and serious risks to human safety in prisons, like if there's a race riot. In a prison, okay, you can divide people by race because that's the conflict. There's a race riot. So it is compelling so that they don't kill each other in a prison. In this case, the appellants and their friends have latched onto the first statement. They say, oh, well, it's okay. So the law has said that we can go back and remediate past discrimination. And they say section 2, perfect. So that's a compelling interest, but they say that's wrong. This court's cases make clear that remediating specific identified instances of past discrimination means remedying the effects of past intentional discrimination. Targeted, saying in other cases here, of course, nobody claims or could claim that Louisiana intentionally discriminated against black voters by not drawing two major majority-minority districts. Indeed, the Middle District in Robinson, another court, itself thought irrelevant that there is no evidence of black voters being denied the right to vote. Do they get to vote? Okay, great. So what's your argument? But the appellants repeatedly claim, they say race-based redistricting, so if we can just create special districts for certain colors of people, it remediates discrimination. It's fixing an old wrong. And that they prove discrimination in other cases, and that there is discrimination against black voters. Now, that's all wordplay, they call it. It should be called out for what it is. They're trying to dilute the term. They're trying to make intentional discrimination to include another concept called vote dilution. Vote dilution is not intentional discrimination subject to the Supreme Court precedent, which is not necessarily based on a finding of intentional discrimination at all. The Robinson appellants are asking the court, they want you to expand the universe of compelling interests that would allow race-based government action. And we don't do that. We have two reasons why you should reject this, SCOTUS. First, there are exceptions in the law that have now been the outermost constitutional limits of what is allowed for race-based government action. On constitutional principle, therefore, it makes good sense to decline to expand that because we've already met the end of it. No more race-based classifications at all. Second, weakening the exception for intentional discrimination, just kind of shoving in vote dilution in there, would also create additional problems as we have seen. Now, if neither litigants nor the courts can have confidence in a governing standard, nobody should be able to come in and wield the awesome power of race-based action. We don't want that. And so one final word, Supreme Court, if the court affirms the judgment below, it should remand to permit the district court and the parties to assess the proper path forward. A remand with the thumb on the scales for them is not going to be consistent. We need a conclusion that the Voting Rights Act that allows race-based districting to occur is illegal. And so affirm the lower level judgment signed by the Attorney General Elizabeth Murrell up to the Supreme Court of the United States. And as we saw from CNN, if that happens and we don't allow special districts to be created to serve certain classes of people at the expense of other classes of people, then and they may lose 19 of their rigged seats, which would be devastating for them, which is why you can see why they want this and all of their rigged rules to continue in perpetuity. One person who's freaked out about the prospect of losing their rigged game is Barack Obama. He said, California, this November 4th, the whole country is counting on you. We're not. We would appreciate if you did the right thing and stopped rigging your elections as you've already have. But he says Prop 50 is going to steal a bunch of seats back. It's going to put our elections back on a level playing field. One state is going to change the rules for the whole country. It preserves independent redistricting over the long term, and it lets people decide. So return your ballot today. Vote yes on 50. So that's from Barack Obama. But here was another interesting thing happening, courtesy of Dustin Grage and many others in Minnesota clipping this, but we appreciate this clip that explains what's going on here. We have a conversation here. Minnesota elections director, just to show you how screwed up and rigged the elections are, he admits that illegal aliens can vote in elections. All they need is a driver's license in Minnesota. I know you're shocked. And so we've got two people, a representative called Anderson and the elections director Paul in here explaining how illegal aliens can just walk right in on an election polling location and vote for whomever they want.
Okay, so the answer to my question is yes. Under that scenario, they get their driver's license, again, because we give them to anybody here. They register to vote. It doesn't match with the social security number, so they're flagged, but they come in as long as they have an ID, which is that driver's license, and they sign that they're, eligible to vote, they can vote. And they're no longer flagged. They're on the system. Is that correct?
Mr. Linnell.
Madam Chair, if I could add, and maybe stepping back from those that are flagged as CID on the roster, for anyone that's presenting documentation to register to vote, that is affirmation of their identity. The driver's license has not been used as proof of citizenship for the purposes of registering to vote. It's affirming that they are who they say they are. So
Right.
In any of these cases where someone were to cast a ballot if they were ineligible to
Just say it.
vote, there are also reports that are generated
Yes.
post-election for voters that are challenged that counties will run to show status of voters that had been updated due to the fact that they've now cast a ballot that can be reviewed and referred to the county attorney.
Okay, so the answer is yes to my question.
Bureaucratic garbage babble from somebody who doesn't want to answer the question. Yes, illegal aliens can vote. He was just explaining without saying it that, they could end up on a list and somebody could look at a list and then maybe send that to the county attorney who could go investigate and prosecute them. Okay. So did their votes count or not? Did you disqualify them? Is there any mechanism to kick that vote out, or does it just get counted and put on a list? It gets counted and put on a list. That's why he didn't want to answer it. So voting rights in America, major battleground. The Supreme Court is going to be hearing a very important case on the Voting Rights Act. We'll, of course, have the highlights on that. Keep our eye on this to make sure our elections are no longer rigged by the Democrats. Thank you for subscribing and joining as we continue our coverage on this one.